I'm attorney Phil Jusino, and this is WLINY's Finding Common Ground here on Altice. My guest for this evening is Gary Jacobs. He's the president of Americans for Legal Reform. Gary has been on my show. This is the second time, my first time on Altice. I've been on his show twice. Tell us a little bit about Americans for Legal Reform.
So we're the oldest legal reform group in the United States. It was founded by Carl Ann Cesaro over 20 years ago.
Carl's been on my show too?
Yeah, Carl's been on the show, and I know he watches it a lot too, and we talk about a lot of the subjects that you do. And what we do is we're really more of a networking group where we bring people together every month, the first Tuesday of every month at the Plainview Old Bethpage Library. We have a speaker come in, and it's usually related to court issues, but it's just any kind of legal issues, sometimes government issues. We have politicians come in, but we can only do so much, and there's a lot of people who need help, just like the Civil Liberties Union and Family Civil Liberties. You can only help so many people, so we act as a networking group. And you get to meet people, attorneys, like you've been down to the meetings.
And you had a very nice barbecue, I got to say, this past summer.
That's a big networking thing, and you met a lot of people. I know you got bombarded with people looking for advice. But when you're an attorney, at a barbecue full of divorced people,
I should do what May said. I've been drinking, so you don't want advice from me.
That's what May says.
He's funny.
Yep, because you're going to get bombarded otherwise. But we really are a networking group, as well as a resource with information, because we're not attorneys.
And a strength in numbers.
Legal advice. Yeah, absolutely. And people, I think, know, hey, when Americans for Legal Reform gets behind you, they're not going to give up, and they're going to they're going to advocate. We go to court, we do referrals, so things like that. And I think we have a reputation for trying to get behind the right people. We don't just take anybody who comes in, because we have no financial incentive. Whereas an attorney like yourself, even if somebody did something wrong, they're entitled to legal representation if they pay you. And nobody knows, well, if Phil's taking them, does that mean they're innocent? Well, not necessarily, right? So, but if they come,
all my clients are innocent.
That's right, absolutely. But nobody really knows, because they have a right to take everybody. So if you come to Americans for Legal Reform, and we decide to get behind your case, we only get behind cases where we believe the person has been wronged or is in the right. We believe, of course. We never. We can be wrong too.
That's right. Now, if you miss any of my shows, you can always catch us on YouTube, which is WLINY Internet Radio. You can also see my live show, which is Fridays at 8. That's more politics and more social commentary. Gary, you said you have that organization. What are some of the complaints that you hear with respect to family court, or I call it divorce court, Supreme Court, matrimonial court? What do you hear?
Well, we only have a half hour. No, but there's, really it's the thing that we get the most problem with, believe it or not. There's a lot of problems with the system of custody, but it's bad judges, what I call bad judges. And the reason I say that is we always get the same people, the people come in with complaining about the same judges over and over and over again. So really the problem, the most common thing is people saying the judge is bad. And sometimes the judge isn't, but when I hear certain names, then I go, you know what, they're right. This judge has a bias against fathers. This one might not like mothers. This one just doesn't listen to the evidence. This one has a temper. Because for the most part, when we have a judge who treats the person with respect, even if they don't have the outcome that they want, usually people know if what was wrong. Like, I think as an attorney, you probably know in many cases what the outcome's going to be.
I do.
And you have to go through the system, but I'm sure I know it, so you know what the outcome's going to be. You know who's going to get custody many times. You know when I see people fighting over assets, and I go, man, this is stupid. We know what it's going to be.
It's math.
Right? Or child support. And we know what it's going to be. So that's a big complaint. Is judges perjury is a big problem that the courts don't do anything about it. That when people get these false orders of protection, which we call the silver bullet, to get the person out of the house, that we can't blame the courts for the person getting it. But then when they find out that it was a lie, that the courts don't punish the person. There's no repercussions for doing it. Alienation is something I'm passionate about, and that's a big complaint. That the courts don't do anything, and you said it on your show. You don't think they do enough, but not doing enough encourages it, because if they would, if everybody knew in Suffolk County and Nassau County, if you're an alienator, you're going to lose custody if we find out. You're going to pay your husband's legal fees or your wife's legal fees.
And that was a suggestion I made.
I got that from your show.
At the very least, do that.
That would hurt. And that would stop it. But right now, there are, with most judges, I can't say all because we know there's exceptions, but with most of the judges out here, they just don't care. They say we're too busy, we can't get involved. I had a judge once say, listen, alienation happens in every case. What do you want me to tell you about it? They picked each other.
Right.
Too bad. And to some extent, alienation does happen. We bet you're pissed. You're in court.
Right.
But
well, you're right. It's like in politics. If there are no consequences, people are not going to change their behavior.
Right.
If you're a litigant and you see everybody else getting away with it, and you can get away with it, why wouldn't you?
Right. I mean, you have consequence as an attorney. You know that you can get sued.
Sure.
If you overbill somebody, or you lie to them, or you promise them, hey, I'll guarantee you're going to get custody, and then they don't get custody, you're going to get sued. Right. So you don't do it.
Right. And there are consequences.
So
it's
there's
just
consequences for
like
your
an
actions.
attorney steals a penny from his escrow, he's disbarred.
Everybody knows
Doesn't
that.
happen that often because who wants to do that?
Right. Yeah.
So there's got to be consequences. What else do you hear?
We hear length of time, that it takes too long to go through court. And that's a big, big problem. My divorce, I was in court for 11 years. Now I was divorced in 4, but because the courts just kept letting it go on. And the problem is, let's say you're not seeing your kids and the courts just keep adjourning it and adjourning it and adjourning it. Number one, you run out of money because, and I think that's part of the tactic in my opinion, is that they know when they get a difficult case, the judges don't want to rule on it. Because if they give the mother custody, then everybody says, oh, the mother always wins. If they give the father custody, the women's rights groups go crazy. So in these real contentious cases, I don't think the judge wants to make a decision. And they know if we let enough time go by, what's going to happen? They're going to run out of money. Somebody will run out of money and give up.
Oh, they'll settle?
They'll settle. They'll do something stupid because they'll be so pissed. They'll say something, the wrong thing. Now that makes the case very easy. So they let but the damage the damage is just so horrible that it does to people, to the kids, to the parents, emotionally. And it's just really a big, and everyone says, nobody cares about moving my case forward. And yes, it's true, the attorneys many times don't care. Hey, I'm getting paid to be there. But a lot of times it's out of your control too, as you know. Right. It's up to, so letting things go on too long. To me, why does a case have to be even for 2 or 3 years?
Well, family court has standards and goals.
Right.
So for the most part, the judges are told, and referees, get the case done in 6 months. Right. That's why if a case is getting a little bit old, like 4 months, in Supreme Court, that's not old.
Right.
But let's say it's 4 months old, the judge will say, we got to pick a trial date.
Or which you see them do too, I'm sure, why don't we agree that you'll withdraw and refile?
I don't really like to do that.
But they ask that sometimes.
Sometimes they do.
Hey, why don't we agree to, or they'll just put a stipulation on and they'll say, we'll set a control date.
Or you can restore by letter.
Right, so you'll let it, but it's very difficult to get, and I think that they created this situation where when you have so many people getting divorced and they're in court for so long. Every time I joke when I go to to Carlton Avenue over there, I go, wow, business is good today. You can't find a parking spot.
Right.
There's more cars there than there are in the park.
You don't get
there
on time, you're near the stadium.
Yeah, then you're in the mall. So I'm like, something's not right. That like you said, a lot of them, what's going to happen. And if you know, and I know as an advocate, the judge certainly knows. Well, especially what's going to happen.
When a case gets older, you've had a number of conferences. Right. And unless it's a new judge, you kind of know what's going to happen when the judge says, why don't we settle this thing? Right. Mom should get custody and dad will get parenting time, or vice versa. Right. You have a sense of how it's going to go.
Well, that's why if we had shared custody, that's the biggest thing that I personally advocate for, is the presumption of shared custody. And it may not be good for lawyers' business. You probably have to do more of the criminal cases instead of family court. Right. But if you just said there's a presumption of shared custody, and the only way you're going to get sole custody is if you can prove that you're putting that the other party puts the kids in danger. But if you make that false allegation, you're the one who loses custody. Right,
but even with shared parenting, it may be a situation where it shouldn't be 50-50. Let's say you have
I didn't say
5-year-old. Okay.
You can't do 50-50. I mean, technically, what are you going to do?
But even if you started out with the premise, okay, shared parenting, let's just say, or you're still going to say, okay, dad wants half the week. No, but that might not be best for the kid.
Right.
Because if you have a 5 or 6 year old, do you want the kid sleeping at home Monday and Tuesday and then maybe going to dad's Wednesday and Thursday if they live 30 miles apart?
Well, here's my feeling. If you take out the money, a lot of these things resolve. If you take out the financial incentive to have the kid more, because right now the kid comes with the money, right? So even if somebody had a predisposition to maybe share custody, if they do that,
they may not get full child support.
They may not get all the child support. So the kids come with the money, and nobody likes to say it, but the kids come with the money.
Right, and you're right. In some cases, if you said there's going to be X amount of child support no matter what, or let's say you have 2 people that make about the same, and you do a shared parenting, and nobody's going to pay child support. But I've had clients, if you get this for me, I'll agree not to take child support, or I don't want to pay child support. You're right. If you remove the money, but sometimes you can't.
Right. But see, I also don't like you talk about the problems. I don't like this child support formula, because to me it costs, if it's child support, which we say it is,
Right.
not spousal support, not enriching the person, if it's truly child support, does it cost any more to feed a kid when the husband makes $500,000 as opposed to the person who makes $50,000? It costs the same thing to feed the kid. So if you're really getting child support, why does it have to be based on what they make? You feed the kid. It costs on Long Island, we say it's going to cost $200 a week, $300 a week to feed a kid. That's what it should be. When they make this argument, well, we have to pay for the house. Well, when you don't have the kid, are you going to sell the house? You still need a roof over your head. And what's the difference between having a 2-bedroom and a 3-bedroom house? There is somewhat of a difference.
But what about a case where, let's say you have a poor guy, he's making $25,000 a year,
Right.
And then you have a situation where the guy's making $150,000. You don't think the guy making $150,000 should pay more child support than the one making $25,000?
I don't. I really
I do.
think it should be well. See, I look to me because what happens when that person who's making 100-something thousand says, you know what, I want to quit my job and do something that's good for the world. I want to become a priest and make $30,000.
Court could say you
The
can become
courts
a
would
priest,
say
but
you
you're
can become
going to still pay that
So I have
same
a problem
amount.
with that because isn't this America where we have the right to pursue happiness? So what happens? That goes out the window now because I'm in court.
I'll give you an example. I had a client, I won't even give the profession because I don't want anybody to figure this out, but he had a job making a certain amount of money, 6 figures. And he was getting to an age where he didn't want to keep doing that particular job. And he wanted to become something else. And the court said, look, obviously they can't stop him from doing that, but he had a 5-year-old kid at home. And if he took that lesser paying job, that woman couldn't survive here in Suffolk County. And it was by
But what
his
if he was
choice.
married, Phil? If he was married, he could do it. He could say, I'm going to quit my job and start
If
a
they were,
business.
if they're not in court, he could do whatever
Right,
they want.
but that's
to
what I'm
do.
saying. So why now, when he's out of court, does all of a sudden he lose his rights to the pursuit of happiness? And this is not done. Listen, in my divorce, I felt the same way. I wanted to start my own business, and luckily I didn't have to pay child support. But if I was paying child support, they said, well, if you get awarded to pay this number, it's based on what you make today. And I said, yeah, but I think I'm going to want to start my own business, and hopefully I'll make a lot more money, which my kids will benefit down the road. You know, when I die, they're going to inherit all my money,
Right.
and I would give it to them if I want to. They said, no, you can't do that. If you get divorced and you agree to pay child support, you're imputed now at that number, and you're not going to be able to quit your job
Right.
and say, I'm making less money. And I just don't, I think if I was married, you'd be able to do it.
But what about somebody doing it for spite? Says, you know what? I don't feel like being an attorney. I'm going to work at McDonald's. That
Well-
wouldn't be fair to my kids.
But you know what? But here's what I've heard people do make the argument. But you know what? Life's not fair. Just like what if the guy gets arrested and goes to jail who was making one of these hedge funds, and now all of a sudden the kid has no money. Should the government come in now and say, well, you know what? Poor Johnny was used to $1 million because his father was ripping everybody off.
Yeah, but
Let's
it
make
depends.
up the difference.
But you know what? Even
It's
if
not
you're in
fair.
jail, you got to pay child support.
But he theoretically can't. He has no money. You know.
Right, but it was his own fault. Like if you lose a job because you're hit by a truck and you can't work, you
Right.
file a downward modification.
Right.
But if you get arrested, the court can say that's not a good enough reason.
But if he's in jail, this kid's going to suffer because there's not enough money.
He will.
Right. So, well, what happens? The government doesn't come in and say these poor kids. It's not fair.
No, but
It isn't fair.
But the mother may go on welfare.
But we're supposed to be equality right now. So when they say, well, the father makes this, the mother makes this is equality. Women should make the same thing as men. I know we both agree, but it's not that much of a gap
no,
anymore.
but if the guy's making less, then the mother's going to pay more child support.
But that's why I think it should just be when you get divorced, you move on, you have the right, because they take away the incentive for people, like you're saying, they could leave, but it takes away the incentive for people to make money, unfortunately. Because the guy goes, you know what, if I make more money, now I got to pay more taxes, my wife's going to go back to court and get more child support from me. Right. And some of them really say, you know what, I don't want to do it because I don't want to go back to court.
And there's a provision in there that if your income goes up by more than 15%,
15, is that what it is?
She can bring you back, or less than 15, you can bring her back.
But it's not. It goes up very easy. It's like gas prices. They go up really fast. They don't go down so fast.
Sure.
It's a lot harder.
And when they do, the burden is on you to prove why it went down.
Yeah, and then you have to prove that you tried everything, right? I mean,
and the worst
you've done those cases.
The worst is a guy that has his own business because
they never believe him.
What if the economy goes south?
Right.
Then what is the guy going to do?
It really does happen.
He better have a good attorney and make a good argument before the court.
I could tell you. I mean, you talk about that. People come to me all the time for downwards, and they go, well, "I'm going to go in and tell the judge." I go, well, then just save your time because you're going to lose. You absolutely going to lose. But if you bring an attorney who tells you, listen, you have to show your book. Here's the jobs I look for. Here's what I did.
Right.
You know what to do. This isn't. I don't always recommend attorneys. This is a case. If you truly had your income go down, scratch up the money and go in with an attorney because you are 100% going to lose. When people go and go, well, I testified to that. Well, hello, you don't think that's self-serving? you know, to go in and say that.
They want to see proof.
You have has to be proof, and with proof, I do think it does happen. If you have, I mean, I'm sure you've won downward mods where the person really tried to get a job.
When I go in there, because nowadays it's mostly emails back and forth when you apply for it. It's not like the old piece of paper you fill out. So I tell the client, apply for 100, apply to every place you can apply.
Go Monster.
Right, and equal pay, and also lesser.
Right.
You can't come in and say, I looked for 5 jobs that paid 100 grand and there was nothing there. Well, did you apply for jobs that pay 75? And I've had cases where they got the job for 75. You know what? They got a downward modification because the court felt that they were doing the best they could to get a job.
But that's not an easy burden.
It's not
to prove. You really need a good attorney, a family law attorney. I should say too.
And it is incredibly difficult if you're self-employed, Gary.
Yeah.
If you're self-employed or you have a job with a lot of cash,
it's always
courts a lot of times don't want to hear it. They're going to be like, wait a minute. Or the guy that comes in and says, you know, the last 19 years I had overtime. I got served divorce papers, and what do you know? There's no overtime.
But Phil,
now.
as you know, sometimes when people are going, like say they're on a commission, now they're in divorce court. Well, they do get depressed. They're spending a lot of time in court, and they'll say, "Look, my pay went down because I'm in court every freaking month. I'm getting served with the new one." And the judge goes, "I don't care."
You know, the other thing, and it's funny because I've seen judges do it both ways. I've seen judges say, the guy has a second job, he's got to keep the job to support his kids. I've seen judges say, but now he's got to have to visit his kids. So let's say a guy works every weekend to make money when he's happily married. Now he's going through a divorce. When is he going to see his kids? On weekends. So I've seen courts say, I'm not expecting him to work a second job.
Oh, okay, well that's good.
Right, but it depends what you get.
That's rare. Well, that's what we talked at the beginning when you said what's the problem is the judges. Because I tell people you are so much better off in criminal court than you are in family court. I call it, family court meanings, Supreme Court and family court, because it's so subjective what the judges can do. And people go, oh, but there's laws to follow. And I just had an example.
They have a lot of discretion.
The other day, somebody came to me and said, look, I got an order to show cause. I'm pro se. I'm going to court. It says you must return 9:30 in the forenoon before this day. I said, no, you don't return. It's submission only. He said, no.
But you got to find out the judge. Like Judge Leo, you got to be there.
And Judge Lee says the same thing. He says you have to be there because I had somebody miss it. And I said, well, it's not, you don't have to go. He said, well, he said I had to go. But so there is no rule, right? The paper says you must
judges
apply.
can have their individual rules on a particular motion.
Right, so it's very difficult to navigate through this system, pro se.
That's why you want a good attorney. Like even though I know, I still call up. Like if I know it's Leo or Lise, yes,
do you want me to show up?
But if it's not, you don't know.
But I tell people, so that's why I say, and they go, oh, I could read the book. I just had somebody this week. Well, I'm gonna read the CPLR. It's black and white. I go, no. It is not black. There's a difference between Nassau and Suffolk.
I was going to say
which you specialize in Suffolk. You always tell me, Gary, this is my playground. I'm in Suffolk.
Right.
And I tell people, listen, it's Long Island. What's the difference? There is a big difference. Right. Even stuff that I know, signing orders to show cause. Nassau, you drop it off, and they call you when it's ready. Right. Suffolk, they tell you to go up and see the judge.
Even with Judge Leo, you don't get a reply. There's an order to show cause, there's an answer, you don't get a reply unless you get permission. All the other judges, it's pretty standard to give you a reply. So you should read, judges have their own rules.
Judge Leo, you're really getting me. I'm trying to hold back because you mentioned a sore spot, but I won't get you in trouble on your show.
Judges have their rules.
Right.
So you can read them. Look, the CPL law, I'm not saying it doesn't apply, but they have individual rules. Like, do you show up or not? The CPL law is not going to say you must show up if there's a motion.
Right. But even within the thing, there's so much discretion in family court. And then I always tell people, I'll get case law. I said, believe me, for every case law you find to prove your case, the other party's going to find case law to prove their case.
Well, think about it. Someone says to you, what's the standard in a custody case? What's in the best interest, Carlos's old show, best interest of the child. What the heck does that mean?
And one judge, I always tell, that's what I said. They go, you leave it up to the judge. Some judges may say, I always said, look, their religion's important. If it's a religious judge, a conservative, they believe going to church is important. Then you may get an atheist judge who says, you're going to waste your kids' time indoctrinating them into your religion. Maybe it's Muslim, maybe it's Jew. You're going to to them, you're a bad person.
Did you ever hear Tim Tippins?
No.
He does a seminar. There were 400 attorneys there at the last seminar in the border of Suffolk and Nassau County. And he said this. He has a guy who does forensics. And he says, what is really in the best interest? Let's say I said to you, this father will raise a kid who will be a high income earner. He will be an overachiever, but he's going to have an ulcer by the time he's 40, and he's going to become an alcoholic because he's under the pressure to succeed. The mother will raise a kid that will be more emotionally adjusted. He won't make that much money, and he may live on his mother's couch for a while, eating Cheetos and playing video games, but he's going to be the proverbial happy kid.
Right.
Who's the better parent?
Right.
You don't always know that.
And it scares me to have the judge decide. I mean, even look at the moving target, right? When we grew up, you could get spanked if you did something wrong. I remember when I cursed when I was growing up, I got liquid soap poured in my mouth to teach me not
Right.
to. You do that now, forget about losing custody. CPS is going to take away your...
Like a Christmas story, when the kid
Right,
curses
yeah.
and they put a bar of soap in the kid's mouth.
Exactly.
You can get away with that.
Right.
You do that now, a neighbor or grandma's calling CPS,
Right.
and you're going to get a knock on your door.
What about smoking?
Yeah.
I've heard some judges say if you smoke, then you're not a good parent
Well,
because you're smoking around the kid.
I know a judge who would put that in the order. Say, don't smoke. You can smoke. Don't smoke around the
kids.
child. And you really shouldn't.
Listen, I agree with it, but some judges may smoke and say, well, I smoke. Listen, I grew up with my parents with the windows rolled up, with my father with the pipe and her mother with her cigarette.
With no seatbelt.
And that's and that's a perfect example. Look how screwed up I came out.
But you
so that
survived.
proves my case. Well, we'll see.
Hopping up and down in the station wagon in the back of the vehicle.
Facing backwards with the door
You know?
open, sucking in the fumes.
And we survived.
But that
We
changed,
made
right?
it.
Back then, they would have said, oh, these are great parents. They're taking their kids on family vacation. Doesn't matter that there's smoke
Right.
and no seatbelts. So
Now you can't even drive with the kid in the car. Come on, it's pretty strict.
But
I'm only kidding about that.
But that's why to me, take away this thing and just share custody, because I don't want the judge. Listen, people say, oh, this guy's a jerk, this woman's a jerk. Well, Judge McNulty hated me. She thought I was an a-hole, I'm sure. And maybe to her I was, but other people like me. So I don't want her to, and she decided based
There's
on
a
that.
few out there.
You know, there's a few, yeah, my ex. So, but I'm saying, you don't want people deciding who's a jerk and who's not a jerk and who's, of course, we know when somebody's a really bad parent. You know, they're doing drugs around the kids, they're putting them in danger.
Sometimes it's obvious.
You know, that stuff, nobody's going to say that person should have I still believe it or not, though, I don't know how you feel about it, but they should have contact with the kid. Even if they're this drug addict in a bad, now it should be in a supervised, safe environment.
EAC or something like
Whatever,
that.
or a family member who's a policeman or responsible. But I really think it's, to keep a parent from their kids should be like almost never, even people who are in jail for murder. Right. Their kids come and see them. They still have a bond, it's still their parent.
Most judges, I think, will bend over backwards to make sure there is some kind of contact. It might not be what they want.
Right.
They might say, I don't need supervision. Yes, you do.
But they let too much time go by is what, for example, these orders of protection. If you get kept a stay away order of protection, you can go months without seeing your kid.
Right.
And that
But that's
damage
why
never comes back.
I'm glad you mentioned that. And a lot of times people don't realize this. All the orders of protection, what do they say? Visitation subject to a court of competent jurisdiction, either family or supreme. A lot of people come to me and they say, oh, it says I can't see my son, little Johnny. And that's the end. It's not.
Right.
Run into court immediately. Because even if you have an order that says you can see John on Monday, Wednesday, Friday, guess what? If there's an order of protection, you don't get that.
Right.
But a subsequent order you can get.
Right.
So you can run into family court or supreme, get an order that can say, okay, you can't go near the kid except Monday, Wednesday, Friday.
Right.
You could do that. A lot of people don't realize. They think once they get hit with an order of
But
protection.
does the judge, is that a possibility that the judge would say, look, well, this other judge gave it to you, but I'm going to...
It happens all the time. Happens
even
all
if
the time.
it's in family or supreme,
Yes.
not criminal?
Doesn't matter.
Okay.
Because it's a court of competent jurisdiction. So if the parties are not married, of course it's family.
Right.
If there's going through a divorce, you go to Supreme Court. A judge is mindful of that and will say, I know you can't see your kid, but you should be able to. So it's going to be at the 6th precinct, pick up and drop off.
Right.
Or curbside. If you have a kid who's 10, you could just sit in your car.
Right. We'll see
and
if
the
many
kid
times
can
the
play.
allegations involve if the person really
That's
wants
different.
to do the silver bullet,
Right.
they'll somehow involve the kid.
Right.
They'll say, my husband hit me and my kid was in the room.
Right.
To wrap him
but
into it.
But assuming there's not a threat to the child.
Right.
You're right. If they say that, then the court might say, we're not doing
We're
anything.
not taking any chance. Well, that's
We're
what
not
they do. They
taking
say
any
we're not
chances.
taking, and that's the problem because they don't want to be in the front page of the paper. Instead of saying, like we talked about earlier, you need someone to come in and sort of give the judge an out to say, hey, this guy I don't think is a danger. I'll watch him. Because keeping kids from their parents, to me, it's such a cruel thing. And I've heard many people say who were in the army and in the Navy and they're fighting in Iraq and Afghanistan. They come back and they're in family court, and I've had several of them, 4 of them to be exact so far, come to me and said, I'd rather be there getting shot at than be in family court and go through what I'm going through, having my kids taken from me. Which, I mean, how sad is that?
That's very sad.
And listen, I have my kids withheld from me. It's a horrible thing. And, we talk about all these people, doing horrible things and shooting people. And to me, you're pushing the person to do something.
Right.
You can't taking away a person's kid from a bench. Say, I'll come back and right now you have Christmas time, and people are calling me. And I'm sure they're calling you.
Yes.
Hey, I want to see my kid for Christmas. It's an emergency. and they file an emergency order. Judge, it's an emergency for everybody. But isn't it an emergency to see your kid for Christmas? Get into the damn court.
And often you can. Sometimes it's better to do it in Supreme if you're married, let's say.
Oh, is it better?
Quicker. You can.
Okay.
I can send a letter to the other side, right? Then I can file an order to show cause, and 24 hours after that letter is sent out, I will be in court before a judge.
Yeah, that's good. That's good to know.
Family court, you're not going to be there as quick.
Which, like you said, you can't go there if you're not married, though.
No.
Which I don't understand.
Yeah.
Why you can't go to? Why, if you're not married, you can only go to family? But you have
I'm
to
pretty
explain
sure
that because I don't understand
you could probably file, but if you're not married,
Right.
Your family court is really the place you're going to go.
Right. But you're not allowed in Supreme Court, right?
You might be able to file. I've never done it that way, to be honest with you.
Nobody does. I thought it was like a law or something that you
Yeah.
can.
But I think if it's, they both have concurrent jurisdiction. Just that family court can't give you a divorce.
Right.
But you can go
You
to
don't need a
family
divorce
court.
then.
But family court is doing a better job than it used to. I remember you used to file a month later, Gary, you'd get a court date.
With the judges.
Now I file and it's pretty quick. Well, I'm saying about the timing.
Oh, yeah.
The timing.
Because now, that's a problem is they put these support magistrates and hearing officers, and not that all of a sudden makes you an amazing person if you're wearing a robe, but there's problems with appeals and who do you complain to if you have a hearing, judicial hearing officer. You can't go to the Judicial Review Board because they're not acting as a judge.
No.
And who do you go to? You can't go to the bar; they're not acting as an attorney. So who do you go to? The chief judge who appointed them? It's very difficult,
Well, don't forget, when they sign that piece of paper, they have all the power of a judge.
But except for you can't. I just did one. The guy signed it, right?
Right.
Well, of course, he didn't know he signed it. He didn't understand what he did. And then we filed a judicial complaint, and they came back and said they're not a judge. We don't handle it.
You can still appeal if you don't like the decision.
Oh yeah. You can appeal it, right? But you can't file a complaint.
Oh, really?
Yes. I mean, so you're stuck in a no man's land.
No.
So do you recommend people agree to it? Or does it depend who it is?
It depends who it is, but I had a case one time where I told my client, stay here, you're better off. She was there the time before me, before I got hired, and she didn't like the attitude of the of the referee.
Right.
We went before another judge, and that judge was ticked off that he got that case.
Right.
Because he's like, why did you guys come here? Well, he found out my client didn't want to stay before the referee.
Right.
And he kind of held it against my client. We ultimately settled it, but I could tell he was not happy that the case came to him.
Yeah, such a problem because I don't know. People have asked me, what do I do? And my answer is, depends who it is.
Yeah.
If you have a good referee,
I gotta say, the referees that I deal with on a regular basis, I've had good vibes from them.
I've had better from referees than the support magistrates.
Oh, really?
I haven't had good luck with support magistrates.
Yeah. Well, you got what, like 7 of them? 7, 6?
I only know a couple of them, but I always get the same 3 that I get the complaints about.
Well, then you could file an objection. It won't be as expensive.
Yeah, right. They could do and sometimes I actually have had some success with objections, to tell you the truth. So that is better.
I have too.
They do take it more seriously than you would think.
I had one where I came late to the case. I was hired by actually an attorney said, I'm done with this case. Phil, can you take over? So I took over. We filed an objection. The judge was mindful that the support magistrate was not treating my client fairly. Said, send the case back. My client had lost. He wasn't my client yet, but he had lost. Send the case back to another support magistrate.
Oh, he changed the support magistrate.
Changed the support magistrate, and we won.
He did the right thing.
We had a full hearing. Right. He did. I think it was Judge Hughes, by the way. But he did the right thing.
I like Judge Hughes.
He did the right thing. He sent the case back, and he knew that if he sent it back to the original support magistrate,
they would just be more careful.
My client would have lost again.
Right.
But they did that.
Yeah.
We got to wrap things up. Kate, things went by very quickly, but
too fast.
I want to thank you for joining. You're going to come on again. You've got to think of some.
It went a lot faster than court.
That's true. That's true. But I want to thank you for coming on the show.
Thank you.
Really
Thanks for having me.
it.
Appreciate it.
I'm going to have you on again, and we're going to have some
good.
good
Look
topics
forward
to talk
to
about. Thank you. Stick around for the next segment. I'm attorney Phil Jusino, and you're back with Finding Common Ground here on Altice. I want to change things up a little bit. Last segment, we talked about family court, and we talked about divorce court with Gary Jacobs. I want to do a little bit about criminal law right now. It's one of my favorite topics. I'm a former prosecutor here in Suffolk County, and I've been doing criminal defense for the last 28, 29 years. I want to go over what you should do if you're arrested or you're contacted by the police to surrender yourself to be charged with a crime or violation of the law. Before we get to that, basically 3 forms of a criminal activity. One is what they call a felony. A felony is the more serious. It is punishable by more than a year in jail. You could get less, but it could be more than a year in jail. Felonies can range from rape, murder, certain types of assaults, certain types of driving while intoxicated, the more serious crimes. Then you have misdemeanors. Misdemeanors are punishable by up to 1 year in jail. And you have different types of misdemeanors. You have an A misdemeanor, you have a B misdemeanor, you have an unclassified misdemeanor. An A misdemeanor can get you 1 year in jail, a B up to 6 months. And felonies also have different levels. An A felony would be, let's say, murder, and you can have a B felony, C, D, and so on. Violations are the lowest form of, I don't even want to call it criminal conduct. It's a violation of the penal code, but a violation is not considered a crime. A violation could be disorderly conduct. It could be harassment. These are not as serious, and generally you do not go to jail for a violation of law. You could. You could get up to 15 days in jail, but generally, unless you have a very bad criminal record, you're not going to go to jail. If you committed a crime that was serious, in all likelihood you would not be charged with only a violation. So what do you do if you're charged with a crime? A couple of ways it can happen. One could be you get a phone call and they say, we need you to surrender at the 6th precinct. The other one is they just come and get you. They can find you at home, they could find you at work, they take you into custody, and once they take you into custody, the question is, do you get out on station house bail, or do they bring you before a judge the next morning? Let's go back for a second to if you get that phone call and they say you have to surrender. The first thing you should do is contact an attorney, because usually they're going to give you time. They'll say, can you surrender tomorrow at 4? Or we need you to surrender by the end of the day. Gives you enough time to pick up the phone, contact a good attorney. You need to do that, because if you go down without getting an attorney, a couple of things can happen. One is you go in there without an attorney and they feel free to question you. Whereas if you called, let's say you contacted me, I'd call the precinct and I'd say, what are you charging him with? They may not tell me everything, but they'll give me an idea of what this is about. And I will say, I'm sending my client, and even if I don't bring him in myself, do not question him. You can ask pedigree information, name, it's like name, rank, and serial number. Name, address, telephone number, that's it. They can photograph you, they can take your fingerprints. That's it. Do not talk to my client. If I say that, they're not going to talk to my client. If a person goes in without an attorney and says, I kind of want to get an attorney, oh, come on, talk to us. What do you got to hide? We're going to help you. Just tell us what happened and let's see if we can work this thing out. They're not there to help you. The police are there to charge you. I'm not saying that they're going to do something improper. What I'm saying is they're not there to help you out. They're there to arrest you or to charge you with whatever they're going to charge you with, and to make the case as strong as possible to hand it off to the district attorney. I know that for a fact. So what do? Contact an attorney. Then the attorney can call the precinct, set something up. And also another thing that's very important. Sometimes if you get charged with a crime, they'll say surrender. And you go to surrender, and the next thing you know, you're spending the night at the precinct. And they bring you before a judge the next morning. If it's a minor, low-level crime like a violation, you generally won't spend the night. If it's a misdemeanor, you might not spend the night. They might say, post $100 each count. So you post, if it's 3 counts, you post $300, they let you go. If it's a felony, you're not going anywhere. If it's a misdemeanor that, let's say, involves potentially an order of protection, they will probably not let you go. You spend the night, you go before a judge. However, if you contact the attorney, I've handled cases where, depending on the charges, I've worked it out where my client surrendered in the morning. If you surrender at night, you're going to spend the night. If you surrender in the morning, if you can work that out, you surrender, let's say, 7, 8 o'clock in the morning, the police can take you to the precinct in the morning so you don't spend the night. You don't want to spend the night in jail. So you get there nice and early, they process you, it takes a while. That's why you have to work it out ahead of time. You can't say I'm going to surrender at night and then show up in the morning. It's not going to cut it. So I can work that out in some cases, where you surrender in the morning, then I meet you in court. So the next step would be, whether you spend the night in jail or whether you surrender in the morning, they're going to bring you before a judge, unless there's going to be station house bail. So you go before the judge, it's called an arraignment, where you enter a plea of not guilty. Even if you wanted to plead guilty, they won't accept it. They'll enter a plea of not guilty on your behalf. As your attorney, I'll be standing next to you. First, I get to talk to you once you're in custody, just to make sure everything is okay. If I was hired after you were taken into custody, I talk to you to find out what's going on. It might have been a family member that contacted me after you were taken into custody. I get to the jail, I'm allowed to speak to you. Then I go to usually it's D11 in Suffolk County, which is a courtroom on the first floor, and I talk to the DA. Sometimes they have a little bit of information, sometimes they have a lot of information, depending on the charge. And then I find out if they're going to ask for bail. They might say, no, Phil, we're going to, ROR is fine, release on your own recognizance. Then I know that you're going to get out in a few minutes or in a short period of time. If the DA says, I'm going to be looking for 50,000 bail, or 10,000 or 500, I have to ask the client, can you make that bail? Or can a family member make that bail? Because if you don't make the bail, you stay in jail longer until you make the bail or you work out a deal. So what I always like to do is talk to the DA, find out what they're going to ask for. Now, what they ask for doesn't mean that's what the judge is going to do. I've had many cases, the judge says $10,000. And because I make the argument to the court, my client has never been arrested before, or they've been arrested before, but they've always come to court. They have a family here, they own a house, they score a 10 on the ROR score, which is 0 to 11. If you score a 1, 2, 3, 4, 5, you're probably not going anywhere. If you score a higher number, you have a better chance at being able to post bail or to be released on your own recognizance. So if I have a client that's, let's say, not even here legally, forget it. Or he's here legally, but he lives in Connecticut and he's more likely to flee. Okay? I would try to work out the best deal possible, but I understand the court is going to impose serious bail, whatever that happens to be. All right. So what's the next step? The next step would be after the arraignment. Now, if it's only a misdemeanor, it's an arraignment. If it's a felony, right, that's not the end of it. Because with a felony, the decision has to be made whether or not they indict my client. There's no indictment in a misdemeanor or violation. So the DA, let's say it's a felony assault. The DA will talk to me. We try to work out a deal if we can. If we can't, they have to decide either they'll keep it as a felony and they'll indict my client. If we work out a plea, it could be what they call, first you have the indictment, and you could work out a deal where your client takes a plea, let's say, and you sign some papers, and they treat it like he was indicted. Not an indictment. Right? If you don't take a plea, and you don't agree to that, the DA then has really no choice but to either indict you, charge you with the felony, or treat it as a misdemeanor. So they would go to court and they say, although there is reasonable cause to believe that a felony was committed, the people, the DA, feel it is in the best or the interest of justice to treat this matter as a misdemeanor, which means they don't have the world's strongest case. They can treat it as a misdemeanor. Still serious enough where the client could go to jail or be placed on probation, but that's what they do. Now, once the case comes in to the system, let's say it's a misdemeanor, one of the more common types of charges, let's say it's a DWI, or it could be aggravated harassment, or it could be assault third, misdemeanors. Once the person is arraigned, they send it to a courtroom. Not that same day, but you'll get a court date, let's say 4 weeks later, 6 weeks later. You come back, and I talk to the DA in that courtroom, and generally there's a different judge. And then I try to make out the best case possible. If it's an assault, I might say my client was self-defense, or my client didn't do that. Now, if I have any proof or any documents, I'm going to bring those along, even though it's not the trial. So let's say I have a witness that says, your client, Phil, that guy did not hit the complaining witness. I might have a witness statement. I might have a photo showing that my client didn't do a video, or a photo that my client wasn't even next to him when the incident happened. So I try to make the best case possible to avoid my client having to plead to the more serious charge. Now, usually there's a plea bargain where the DA says, okay, it's assault third, but I'll give you harassment. Let's say it's not a serious injury. They could give me harassment. Harassment would be a violation of law, usually a fine, no probation. I say to my client, do you want to take the offer? Now, if he says, I didn't do a damn thing, I didn't touch the guy, or I touched him, but it was self-defense, I say to my client, then we have to go to trial. unless the DA drops the charges. They generally don't drop the charges outright unless they come to the realization that my client is innocent. Now, how does that happen? Let's say I have an alibi. Or let's say I had a case one time, a very serious case. My client was accused of raping a woman that came into his establishment. And he said she did come in. There was some consensual contact, but I did not rape her. My guy was arrested, spent a few days in jail, and then I came across a video of the woman coming in, the two of them engaging in some consensual contact, going off camera, and then when they came back on camera, she wasn't kicking, she wasn't screaming, she was smiling, she waved goodbye. In fact, she looked up to see if there was a camera, and the camera there didn't look like a camera. So I guess she didn't think there was a camera. She called the police. She was arrested. He was arrested. And that's why he spent a little bit of time in jail. Once I had that video and I showed it to the assistant district attorney, the case was dismissed. He was let out of jail. They decided not to charge her, but the DA said I was very angry with the complaining witness because she felt duped. I would feel duped. When I was a prosecutor, I always hoped that everybody would tell me the truth, and if this woman was in fact raped or attacked, that they wouldn't lie to me. Because you don't want, I don't think any ADA wants an innocent person in jail or prosecuted. The same as a cop for the most part. I don't think cops get up in the morning and say, how can we frame an innocent guy? They might mistakenly believe that somebody committed the crime that didn't because of the information that they have. But it's important that the DA does what they're supposed to do, I do what I'm supposed to do, and the judge does what he or she is supposed to do. So in that case, it worked. He did not have to go to trial. The case was dismissed. In fact, about a week after that, I got a phone call from an attorney from the city about a civil case and says, we're going to be suing your client for rape. I said, did you even talk to your client about this? Did you know that there's a video? And he said, yeah, I heard there's a video, but I heard it's not that strong. I said, I'll email. I got permission. I emailed him the video. He saw the video. Needless to say, there was no new case. So I see that my time is winding down for this particular segment, but the important thing to know here is to educate yourself. Find out, first thing you should do is get a good attorney. Find out what you're charged with. Talk to that attorney and be honest with that attorney. Because when you lie, only bad things happen. All right? If you tell the attorney the truth, he or she can help you out. Because even if you did something you shouldn't have done, maybe it shouldn't be the more serious charge. Or maybe there's mitigating factors as to why you did what you did. Or maybe taking an anger management class, or an alcohol class, or a drug class, or something can minimize the punishment that you're going to face. So get that good attorney. Make sure it's an attorney. There are a lot of good attorneys out there. Make sure you get an attorney that handles these kinds of cases. You might get a great tort attorney who handles personal injury cases. That's wonderful. Got a personal injury case? Call that attorney. But if you have a criminal case, call somebody not only that handles criminal cases, but is in that particular court on a regular basis. Because he or she is going to know all the DAs. They're going to know the judges. Doesn't mean they're going to roll over because this attorney is so wonderful, but that attorney knows his audience, and he knows what to do, and he has a certain credibility with that particular ADA or judge. If you need any more information, you can contact my office. I'm Attorney Phil Jusino, and the number is 631-588-3155. At least speak to an attorney. Even if you don't hire the attorney, you're going to get some information. Stick around for the segment that'll come up shortly, and that is segment 3. I'm Attorney Phil Jusino, and you're back watching Finding Common Ground here on Altice. This is segment 3. What I want to do, I started last week. What I'm going to be doing from now on is the last 15 minutes of the show. It's an hour-long show. The last 15 minutes, I want to do a segment called American Exceptionalism. Sometimes it'll be about famous people. Last week it was about Abraham Lincoln. Tonight it'll be about George Washington. It doesn't have to be about famous people. It could be somebody that did something heroic as a firefighter or a police officer or a laborer or somebody that saved a life. I want to bring to the forefront things that Americans do that are exceptional. Now, we all know that in 1776, the Declaration of Independence was signed in a hot Philadelphia afternoon. And at that moment, the guys that signed that document, our founding fathers, they knew that if they lost the war, they would lose their land and they could lose their lives. So they were all in once that was signed. But in signing it, that wasn't the end all. Now, the Constitution wouldn't be signed until 1787, many years later. So in that time, they knew that they had to win the war. There was no second place. So George Washington was selected to be the general of the Continental Army, and he was tasked, and he had a lot to lose. He was a wealthy Virginia farmer. He had status, and he knew that if he lost the war, all would be lost for him. So he went into the war saying, again, there's no second place. He had to win the war. And he knew he was up against it. They didn't have a lot of resources. They had, I don't want to say a ragtag team. Some of these guys were excellent soldiers. But it was a militia, right? It wasn't like, even in the Civil War, when generals are selected, these guys, some of these guys are battle-tested soldiers. This was a militia that was formed. And they had to sign up for the war. So he had to put this band of guys together in a relatively short period of time with limited resources against the most formidable army at that time, the British Army and the British Navy. Now, the reason why I'm talking about this tonight is when I'm going to talk about George Washington, his knowledge of the weather as a farmer helped win the American Revolutionary War. Without that knowledge, the battle I'm going to talk about may have been lost, and if he had lost that battle and was captured, that was the end of it. There wasn't going to be much more to fight over. So as 1776 came to a close, right near Christmas time, Washington crossed the Delaware, and they surprised the Hessians in New Jersey, Trenton. And they won that battle. So then they pulled back across the river. They came back the next day. And when they came back, they were met by British regulars. And it wasn't pretty. They got pushed back. They lost a number of men. They got pushed back to the river. Now, the British didn't finish them off. It was cold out. It was starting to be nighttime. And Washington knew his back was against it. And he knew that where he was stuck was very muddy. And he knew that cannons and carriages could not move in the mud. He was trapped. He knew his only way to win was to march forward against those British regulars and defeat them, which would not be an easy task. So what did he do? He knew by weather patterns that that night was getting colder. And he knew if the ground froze, it wouldn't be muddy anymore. And he could then take his cannons and carriages and wagons overland and attack the British when they least expected it. But he first had to lay the trap. So what did he do? He called his men to light bonfires, so it looked like they were in for the evening. And there were big bonfires, a lot of light, and the British could see this, and they said, oh, Washington is in camp for the night. We'll get him tomorrow. The British were expecting Washington to hunker down, and in the morning, they were going to be attacked with any place to run to. The river was behind them, and they weren't going to do another risky river crossing. So before daybreak, the ground froze. He was able to march toward the British soldiers, and he defeated them. Now, what did that do? It was still early in the war. The war was not anywhere near over. But by defeating the British in Trenton the way he did, the element of surprise, the heroics of it, that the word spread. France found out about this. Now, France was sitting on the sideline wondering what they should do. Because if they came to the Americans' aid and America lost, right, the colonists, they would be in trouble. Because the British would say, wait a minute, you sided with the wrong team. They didn't want to go with the British, but they were waiting. They were hedging their bets. After the word got out that the Americans had a big victory. That led to the French declaring war against the British, entering the war on the side of the Americans, which helped us win the war. Kind of like, and I'm going to digress a little bit, kind of like in the Civil War, when earlier it was about states' rights. And Lincoln wanted to make it about slavery, which he felt it really was. And I always say, I don't care what you say, it was mostly about slavery. If there was no slavery, that war in all likelihood would never have happened. But just like Washington needed a victory to line up the French on our side and not on the side of the British, Lincoln too did something like that. He signed the Emancipation Proclamation. So it was definitely then, without question, about slavery. So the French couldn't come in and help the South, because if they did that, the French people would not stand for that. And they would probably do something like they're doing now with Macron in power in France, burning the city down, burning Paris down. So once France realized in the Civil War that it was about slavery, even though the Emancipation Proclamation didn't end slavery because the South wasn't going to follow the Emancipation Proclamation, it was enough to turn the tide back to George Washington. He knew a key victory would put him in a position to then be able to call on the French to say, look, we just won an important battle. It's early in the war. The war wasn't even a year old yet. Because remember, the summer of '76 was they signed the Declaration of Independence, and here we are, December, January, just into 1777. So the war had a ways to go, but that was a key victory. Now that's what American exceptionalism is all about. Now, we didn't really have America as we now know it at that time. In the Civil War, we were still a young country. It was two factions. You had the South and the North. And the South was almost like a separate country. It was still America. But they saw themselves as Southerners. Like right now, you could be from Alabama, you could be from New York, California, maybe not California, but you could be from anywhere in America. And you say, I'm an American. Around the time of the Civil War, they were Americans, but they saw themselves as Southerners. So it was no big deal to them to break off and form their own country, the Confederacy. Jefferson Davis was the president of the Confederacy. He was mirroring what we had. We had Abraham Lincoln as our president. They had a president. We had lawmakers. They had lawmakers. We had an army. They had an army. Now, with Washington, think about it for a second. If he had lost that battle and he was captured, there probably wouldn't have been an America, I'm sure there wouldn't have been an America as we know it. It would have been something else. The British would have won the war, and they would have imposed what they wanted on this new continent, the Americas. We would be under the British crown. And we fought the war because of taxation without representation and the way they treated us. They were treating the colonists as second-class citizens. Often that's what a conquering nation does. And they were doing it without having conquered us yet. They were just in charge because most of the people there were British. And many of them were loyal to the crown. That's why I marvel, and as an attorney, I studied the law and I studied history. And our founding fathers were the most amazing group of guys I think ever collected on this planet. When you think about it, Ben Franklin, Adams, Jefferson, these men were geniuses. They weren't just politically astute. Ben Franklin had patents. Jefferson was an architect. He was creating buildings. Think about it now. Most of our politicians, we're lucky they know what the hell they're doing in Congress. And these guys were experimenting with electricity, like Ben Franklin. He was the first postmaster. He was creating things that far surpass anything of the day. Science, technology. And you had men like Washington. So he was a guy that was picked as the general of the Continental Army. And when he won the battle years later, there was some talk about, well, maybe we could give him a lot of power and make him a king. Not all the founding fathers, but there was talk about it. And he said no. Because even if he was the kind of guy that wouldn't have been like King George III, maybe the next guy would have been. Maybe he didn't have any kids, but let's say when he passed away, the next person that was king or monarch or something like that, they would have been in a position of power. And our founding fathers knew better that we couldn't have that kind of a monarchy. I wouldn't even call it a government. You had a king. He was in charge. Not like today. The king is a figurehead, the queen is a figurehead in England, and you have parliament, and you have the prime minister. So George Washington becomes president, our first president, and he put together a government, which was pretty amazing. Went through a war. The resources were limited. They didn't have a lot of money in the treasury, and they put together something. And with Jefferson, and he wasn't there for the signing of the Constitution. He wrote the Declaration of Independence. He was in France at the time. And what's amazing is these guys came together well over 200 years ago, and they put together a document that lasts to this day. But not a lot of changes. And we have the Bill of Rights, the first 10 amendments to the Constitution. Now we've had additions like the 13th Amendment around the time of Lincoln that ended slavery. But it was a document that could grow, where things could be added in an orderly fashion. And as an attorney, we have the Constitution. The police must follow the Constitution. Judges must follow the Constitution. So American exceptionalism, George Washington and our founding fathers, amazing. I wish we had half that talent nowadays. We'd be really going in the right direction. I want to thank you for watching the show this evening. If you missed a show, if you came in late, or you didn't get a chance to see prior shows, go to YouTube. WLINY Internet Radio. You can catch the shows. If you like our show, you can see it Fridays, 8 o'clock. Hit like. Share it on Facebook. I want you to go to YouTube and subscribe. Our audience has been growing, but it'll grow exponentially with people like you that watch this show, that enjoy this show. We have guests that come on. Earlier today, we had Gary Jacobs. He came on. He's been a guest on my show before. To add a dimension to the show that one person only can't bring. Last week we had a paralegal and a former client of mine, Jolene Cross, who brought a perspective. Next week we're going to have another guest. But if you like this show and you like politics or social commentary, join us on Fridays at 8 p.m. live. WLINY Internet, Facebook Live. We have a chat room. You can enter the chat room and you can actually say things that I'm going to see live, real time. There's a TV right above where the camera I'm looking at right now, and it's a chat room. So if you say something, you can disagree with me, agree with me, whatever you want to say, I often comment about it when I see it. So I want you to watch Friday's show at 8 o'clock. Thank you very much for joining in. We'll catch you next Saturday at 10 in the morning, and also for your insomniacs, Thursday at 1 in the morning. You take care.